Welcome to this December opening session on new ways of working and the future of work organized by the World Jurist Association. My name is Diego Solana, and I am representing this organization focused on a global campaign promoting the rule of law as a guarantor of peace and liberty in the world. The biannual World Law Congress will take place in Colombia on November 17 and 18 of 2021. Together with the Colombian authorities, we decided to anticipate some of the topics to be discussed in Colombia next November and start disseminating these discussions with leaders of all around the world. This opening session will be focused on two main topics. The first one is the tremendous effect of the pandemic in the way we work. Millions of people are currently working from their homes, and this situation may continue once the pandemic is defeated. On the other hand, it is clear that the world of work is changing. Artificial intelligence, automatization, and robotics will make this shift as significant as the mechanization in prior generation of agriculture and manufacturing. While some jobs will be lost and many others will be created, almost all of them will change. This opening session has been led by the Spanish attorney Íñigo Sagardoy, president of Sagardoy Abogados, and Christina Blacklaws, that has offered to host in London this opening session. Christina is a very well-known attorney who currently is the immediate past president of the Law Society of England and Wales and the chair of Lawtech. Our expert panelists come from United Kingdom, from Germany, from South Africa, and from and that's it. Sorry. Following this brief introduction, I would like to share with all of you the video of Colombian President Iván Duque, welcoming to the World Jurist Association and the World Law Congress 2021. Thank you very much.
I am very pleased to welcome you to the beginning of the 27th edition of the World Law Congress. More than 14 opening sessions that will conclude in our cherished Cartagena de Indias next year. It is an honor for all Colombians to host for the first time an edition of this true celebration of democracy. We received this designation as a recognition of our efforts in defending the rule of law as a guarantor of freedom, order, peace, and concord in our society, precisely when we celebrate the 30th anniversary of the 1991 Constitution, as well as the bicentenary of the promulgation of the Constitution of Cucuta. The world is facing challenging times for many reasons, including the COVID-19 pandemic and its huge socioeconomic consequences. So we must strive to amplify valuable dialogues, such as those promoted by the World Jurist Association, the World Law Foundation, and other sponsors of this very important Congress. That is why I salute the design of this innovative, ongoing format that will hold these online opening sessions with free access. It will be a great opportunity to promote the strengthening of the rule of law as the fertile soil to allow the growth of well-being, development, and freedom for our citizens. I invite the international legal community to participate actively in this democratic journey, which will be held throughout the next months in top cities like Washington, Miami, Mexico City, Buenos Aires, Hong Kong, and other cities around the globe. I wish you the very best during these months of knowledgeable building and sincerely welcome you to our country, when we will continue to work to build a better legal system and a better future for all based on the rule of law. Thank you so much.
Well, hello everyone and welcome to London. I very much wish that we could be here in person, but that is not to be the case this year, I'm afraid. Hopefully many of us will be able to visit the wonderful Colombia next November and join together to discuss a whole range of incredibly important issues. My name is Christina Blacklaws. As Diego has already said, I am a former president of the Law Society of England and Wales, a lifelong campaigner for the rule of law and around diversity and inclusion issues, and a very proud president of the UK chapter of the World Jurist Association. And delighted to be involved, particularly from my own home city. My current roles is I'm a non-executive director for large global law firms, and I also chair 2 UK government bodies in the technology and law space. And this is, ladies and gentlemen, such an important issue. I don't think there is a more challenging one for us now, particularly at this time and place. So I'm going to start with a few opening provocations for the panel about the future of work before we go to our esteemed panelists for their views. First of all, I would say that this global pandemic has changed everything, everywhere, when it comes to the future of work. We have had in the UK a recent study which evidenced that COVID-19 has sped up digital transformation by approximately 5.3 years. So that means that all of us, but let me talk about those of us who are legal professionals, but all of us have become more tech savvy, more functionally familiar with technology, and much more digitally enabled than we were just 8 months ago. So I would say that we are probably now in the best place we could be to take on board new technological innovations which will transform the way that we deliver our services. Maybe panelists agree with me, maybe they don't. My second provocation is that I think remote working, so not working in the office full time, is absolutely here to stay. Certainly in the UK, another very recent study showed that 93% of office workers did not want to go back to going into an office every single day. I think in the legal profession, again, this will become something that will be in effect a hygiene factor. So if your law firm doesn't offer your staff the opportunity to work where they want to work, then you may find them going to competitors. And my final provocation question is this: if that means that we will now have to get used to a world where we have a hybrid working situation, where some people will be working from home, some people will be working in part from home, in part in the office, some people will be working full-time in the office, how are we going to make that work for everyone? How, in particular, are we going to make that fair so that remote workers have the same opportunities to get in front of good clients and get promotions as those who are in the office? And this, I think, is particularly important when it comes to the question of diversity and inclusion. It may be, for example, that more women work remotely because they have childcare or elder care responsibilities. How will this impact upon disabled workers? There's an awful lot here for us to unpick, and I would be bold if I suggested that our panelists are going to answer all these questions, but I'm sure that they are going to give us some amazing insights into these issues. I very much look forward to hearing from them. And so without further ado, can I hand over to your esteemed chair, Íñigo. Thank you very much.
Muchas gracias, Cristina. Muchas gracias por la presentación. Gracias a Diego Solana en nombre de Javier Cremades y de la World Jurist Association por esta magnífica invitación y esta magnífica iniciativa que realmente ha acertado en el tema y ha acertado en la selección de los panelistas para tratar de un tema que yo creo que, como bien decía Cristina y también decía Diego, de absoluta actualidad, por lo menos en el ámbito nuestro, en el ámbito del mercado de trabajo, en el ámbito laboral, ¿no? Voy a, en primer lugar, a introducir brevemente a los panelistas que están hoy con nosotros y luego ya entraremos directamente en materia. En primer lugar, es un placer presentar a Renate Hornung-Draus, alemana, está en Alemania, es vicepresidenta regional de la Organización Internacional de Empresarios, IOE, para Europa y Asia Central, representante de la Confederación de Asociaciones de Empresarios Alemanes en diversos organismos internacionales y una grandísima experta en temas laborales y del mercado de trabajo. En segundo término tenemos a Daniel Funes de Rioja, que nos acompaña hoy desde Argentina, desde Buenos Aires. Es vicepresidente de la Federación Industrial de Argentina, presidente de la Cámara de Comercio y Producción Interamericana, es presidente honorario también de la Organización Internacional de Empleadores, IOE, y bueno, es fundador y presidente de un prestigiosísimo despacho de abogados laboralista, buenos amigos nuestros, Funes de Rioja, con presencia en toda Argentina. En tercer lugar, tenemos también con nosotros a Michael Burd, que nos acompaña desde Londres, de Inglaterra. Michael, aparte de buen amigo desde hace ya muchos años, es socio director del área laboral de la firma Silkin en Londres, en firma líder en materia laboral en el Reino Unido, y ya digo, hemos compartido numerosísimas conferencias, numerosísimos proyectos, trabajos conjuntamente, y Michael es un gran experto y speaker en conferencias sobre el futuro del trabajo y en especial sobre el teletrabajo. Yo creo que también nos aportará gran luz sobre esta materia. Y finalmente tenemos a Hatsima Silova, que nos acompaña desde Sudáfrica, exsecretario general del Congreso de Sindicatos de Sudáfrica, ex premier de la provincia de Gauteng de Sudáfrica y también gran experto en toda su experiencia en temas laborales y de futuro del empleo. Y como decía también Cristina y Diego, pues como pueden observar todos ustedes, tenemos un panel internacional de primerísimo nivel y que nos va a arrojar mucha luz en este tema. Para mí es un honor moderar esta sesión. Creo que sinceramente, si hay uno de los grandes temas de los cuales está hablando todo el mundo, tristemente, del coronavirus, son los grandes cambios, las grandes transformaciones que está ocurriendo, como bien decía Cristina, en el mercado de trabajo, cambios en las empresas, cambios en las formas de trabajar, cambios incluso en el lugar de trabajo, la forma como vamos a trabajar en el futuro. Y realmente, si bien había una tendencia de que esto estaba ocurriendo, el coronavirus, el COVID-19, lo que ha hecho ha sido acelerar esa transformación, ¿no? Y se puede decir, a mi modo de ver, que estamos en un punto de inflexión, ¿no? En un punto de inflexión respecto a la transformación de las organizaciones y del mercado de trabajo para el futuro. Vamos a ver, yo creo, y así sucede por lo menos en nuestro país, en España, cambios regulatorios de calado, cambios en las formas de organizar las empresas y estamos viendo y asistiendo a grandes debates a nivel europeo, a nivel iberoamericano, que realmente estamos pues viendo un poco cómo realmente va a haber decisiones de las empresas, de los estados, para cambiar todas estas cuestiones referidas al mercado de trabajo. Y ya sin más, no me quiero extender mucho porque lo importante es escuchar a nuestros grandísimos panelistas y voy a empezar a dar la palabra para que Renate Hornung nos haga unas pequeñas primeras reflexiones respecto a esta temática y a las cuestiones que ha lanzado Christina al panel. Y muchas gracias, Renate, cuando quieras.
Thank you very much, Íñigo, and good afternoon, good morning, good day to all participants. It's a great pleasure and an honor to be a panelist in this distinguished conference panel. And I will try to make a couple of comments based very much on Christina's provocative introduction. So it's a great pleasure to participate in this panel. Let me first of all say that I very much agree with Christina's analysis that the measures which were taken in most Western countries against the pandemic or to contain the pandemic have indeed accelerated hugely digital transformation where it was possible. And they have also shown maybe deficits in digital infrastructure in many countries. They have also shown certain limits. So I will come to those in a minute. Let me just explain to you maybe at the outset, since you want to speak about regulation as well, what is the regulatory situation in Germany right now? In Germany, the current legal status is that we have legislation regarding what we call telework, but telework refers to a person working from home. And of course, telework is in a way remote working, but it's a fixed working place. It's not mobile work. And this telework implies that, of course, it has to be agreed between employer and employee. And if this telework is then taking place, the employer has practically all the duties regarding the health and safety, occupational health and safety, making sure all the rules regarding sort of ergonomic situation at home and the working time at home and so on are respected. And in this regard, also, let me remind you of the recent judgment of the European Court of Justice regarding the complaint of Comisiones Obreras. So it's, I think it's the right context here because we are all Spanish or also watching very closely what happens in the Spanish culture countries. Where the European Court of Justice actually introduced an obligation for the employer to make sure that working time is documented. And in this context, we have a very vivid discussion, legal discussion in Germany going on today, which started off with the Labor and Employment Minister, Hubertus Heil, who wanted to introduce legislation giving a unilateral right to each and every employee to request 24 days minimum of mobile work per year. So this unilateral right has met a lot of criticism because we all know that telework or mobile working is certainly possible for the legal professions, but there are many professions where mobile working is not possible. You have to be there physically. So also regarding the obligations for the employers, this has met a lot of criticism because the employer must be able to make sure that the conditions for safe work are actually met when mobile work and telework is taking place. So this led the government to change its ideas and to introduce or to discuss, propose a right for the employee to request from the employer mobile work. So this is the current state that probably in January we will receive a draft legislation which will contain a right for the employee to request mobile work. But this request will not be limited in time. So, and it will also not be limited regarding the category of worker. So every employee will be in a position to request mobile work. And then The employer will have to examine the request, and if it is not possible, he has to give a motivated answer with the reasons why mobile work is possible or not possible, or only possible with certain limits and so on. So this is the situation. And we also think that there is it is important to distinguish between mobile work and telework, because mobile work so far as a concept does not exist in German law. The only concept existing is telework, the fixed working place at home. And in mobile work, obviously the employer cannot be held responsible for health and safety provisions, for instance. He can ask the employee to make sure that he respects it. He must be able to delegate it. But again, that poses huge challenges. And also the other challenge regards the working time legislation and precisely the consequences of this ECJ ruling in the Comisiones Obreras case on documentation of working time, which the employer must be able to delegate to the worker, and at the same time he somehow has to be able to control also the working time. So all these questions are still not really answered or clarified, but they will be discussed in the political process in the months to come. Now, let me make a couple of final comments on, well, how I see the situation regarding telework. Certainly, Christina is right in saying that the measures against this pandemic have changed a lot in our working reality. But they have also shown, I think that's what we need to look at, the limits of mobile work, the limits of remote work. And Christina, you already mentioned the impact it has on women, especially. Now, I'm not talking about top lawyers or managers, but I'm talking about very simple professions where certainly this sort of obligation to stay at home and do work from home has led to probably more difficult situation for many women because they are faced with additional societal expectations on them regarding the education of children, especially when the schools are closed and they have to look after the kids at home. And so that's something to be watched very carefully. A second issue is also that we all know, even in the legal professions or even in collective agreements, wherever you have difficult negotiations, they become more difficult when you do it on a video conference. When you are not present physically, you don't meet your negotiating partner physically. And we could see this actually in the European Union, I think, where we had lots of difficult negotiations, for instance, on the multi-annual financial framework, for instance, or other difficult negotiations. I'm not going to mention Brexit since we are in London. But I think this situation has shown that where the negotiations become very difficult and you have to find a compromise in a very thorny field, probably the physical presence will be much, much better than doing everything through video conferences. And that's a point to be also taken into account. We also have the issue of data protection, and I have to say, especially as Europeans, we are very sensitive to that because at the moment, the technology we use, including the Zoom technology we are using right now, it all goes on to US servers, and we all know the legal situation for US companies or any data being present on US servers. It poses huge problems of data protection. And so my final comment will be to really look very carefully at sort of trying to avoid running or creating a new fashion, or which reinvents the wheel. Because let me remind all of us that we have had this kind of drive, for instance, with Facebook, where some years ago, all employees were sent home to mobile offices. The central offices were just sort of abolished, more or less. And then after a certain time, everybody was ordered back to the office. because also it became clear that if you do everything on mobile work, all the team building, all the corporate culture is practically impossible to really to really manage or to develop, because you need physical presence of people. You need the kind of informal chat on the corridor, in the coffee bar, to be able to forge a kind of a team and a corporate culture. So I think, as Christina said, what we will see in future is a hybrid work culture, where we will certainly have increased possibilities, and everybody is appreciating these increased possibilities for mobile work. But we will certainly also need to have physical presence and sort of our offices where we can meet people in person, if we want to really have and forge a corporate culture, if we want to come to constructive results in very difficult issues. So my guess is, let's look at it in a very cool, in a very nuanced way, analyze the pros and cons, and see how will this hybrid situation be positive for both employees and companies, because we need both a corporate culture and individual freedom, and indeed social inclusiveness and equal opportunities for everybody. Thank you very much, Íñigo. Thank you, and looking forward to the discussion.
Muchas gracias, Renate. Muy interesante. Realmente ahí hay un debate también en otros países, precisamente referido a la gente más joven, a los que se incorporan a las empresas y que realmente, claro, necesitan de un cierto mentoring, de un cierto cuidado, y si todo es teletrabajo, pues se pierde ese equilibrio, ¿no? Que es muy positivo, sobre todo para las nuevas generaciones, ¿no? Luego hablaremos, si quieres, un poco más del tema de la regulación del teletrabajo, porque hay países como, me parece que Argentina, en España ya tenemos regulación, y yo creo que puede ser interesante comparar cómo estamos en esos países. Doy sin más paso y la palabra a Daniel Funes de Rioja, que también agradezco su presencia en este debate. Y nada, Daniel, cuando quieras hacer tus reflexiones sobre este tema, encantadísimo.
Gracias, Íñigo, and good morning and good afternoon, everybody, all the members of the panel. I'm very happy and pleased to be part of this, because I think this is a very substantive discussion. It's something new. Let me turn to Spanish in order to go faster, in order to explain the situation in my own country. Primero que nada, lo que debo decir es que nuestro sistema laboral es un sistema rígido, con mucha regulación, que de alguna manera propone derecho individual y derecho colectivo, y por esa razón es importante que yo clarifique que este tema había venido desarrollándose en la práctica antes del COVID, desde hace 10 años aproximadamente, de una forma práctica, sin interferencia del Estado, con acuerdos, sean individuales o colectivos, porque hay incluso acuerdos colectivos muy importantes que han tratado de intervenir en algunos, casualmente para contemplar estas nuevas realidades tecnológicas. Pero como dijo Christina, ¿cierto? Hay una aceleración de lo digital, y el COVID ha sido un impulsor muy importante de nuestro propio país. En el mes de marzo, la pandemia y las medidas de emergencia, se dictaron normas apropiadas para contenerla, esa emergencia, y facilitar. Cuando digo el trabajo remoto, no solamente estoy diciendo el teletrabajo, sino también toda forma de trabajo a distancia. Ahora bien, Esto tenía un sustento solamente en una resolución, en la ley de contrato de trabajo, en primer lugar, y en una regulación creada para, desde el punto de vista de los elementos de trabajo que debía tener un teletrabajador y de manual de buenas prácticas en cuanto a health and safety, salud y seguridad en el trabajo. Esta resolución fue suspendida en el momento que comenzó la pandemia, pero paralelamente, y en forma corporativa, el gobierno decidió en el plano legislativo discutir el régimen de trabajo. La primera cuestión que yo planteo es que no hacía falta una ley, pues estaba la figura contenida en el régimen de la ley de contrato de trabajo en términos generales, como cualquier otras modalidades. Y tampoco había niveles de conflictividad que generaran la necesidad de regulación por parte del Estado. Pero se llegó a este proyecto de ley y se sancionó rápidamente, aunque se dejó en claro que solo se aplicaría 90 días después de que terminara la pandemia. Es decir, los hechos se reconoció que la relación que venía dándose entre las partes durante esta emergencia era suficiente y que los supuestos avasallamientos de derechos de los trabajadores a que alude ya no estaban de ninguna manera probados ni justificados, ni tampoco que el sindicalismo no tuviera la posibilidad de negociar colectivamente. Cuando se sanciona la ley, la reacción empresarial fue de contestación a la misma, desde el punto de vista de considerar que tiene errores, que avanza más allá de lo necesario y que complica en la práctica la aplicación de la ley. Y se introduce en la ley de contrato de trabajo, pero lo hace de una manera que restringe la capacidad de autorregulación, pone sobre la mesa una definición limitada de teletrabajo, pues no habla de la habitualidad o preponderancia, la norma típica, con lo cual confunde el teletrabajo habitual con el teletrabajo ocasional. Y por otro lado, se establece también límites desde el punto de vista de jornada de trabajo que son muy difíciles de controlar porque la dinámica misma de la relación muchas veces lo que está guiada es por objetivos y no por tiempo. También incursiona en cuestiones como el derecho a la desconexión, con una casuística excesiva a nuestro entender, así como el derecho a la reversibilidad. Es decir, la posibilidad del trabajador de volver al trabajo de oficina en cualquier momento. Y esto lo hemos cuestionado y resistido. Pero vuelvo a decir, todavía esto es teórico porque no se ha aplicado, porque durante estos meses de pandemia el teletrabajo se está dando sin la norma actual que acabo de... Por eso hemos propuesto reformas desde el punto de vista de una reglamentación que trate de salvar las opciones antes mencionadas. Y voy entonces a responder las dos cuestiones que Cristina ha puesto. La primera es el tema de la aceleración a lo digital. Sí, también en esto quiero ser enfático y afirmativo. La transformación es este impacto se ha dado no solo en empresas tecnológicas, sino en la industria, en general en todos los servicios, y la limitación está dada. Y la limitación está dada en países de extensión como la Argentina, por cuestiones que hacen a la conectividad, a la infraestructura de conectividad. Y diría que la otra cuestión para su es el tema de la formación técnica para la empleabilidad y la percepción que estamos teniendo en todas las encuestas que hemos realizado muestran que hay una preparación y una posibilidad verdaderamente de alta respuesta positiva, tanto del lado de los empresarios como del lado de los trabajadores. Por ende, mi conclusión al respecto es que estamos frente a un fenómeno no coyuntural, sino estructural, y que va a acompañar, que está acompañando el proceso de la robotización y que los sindicatos van a tener también que adecuar su paso a contemplar estas nuevas realidades del mundo. Todas las perturbaciones, pues, que produce el COVID muestran, sin embargo, adaptación y reacción positiva en este campo, que esperemos no sean perturbadas por una legislación que las inhibía y no se recogen las observaciones que hemos planteado para una adecuada reglamentación. Concluyo diciendo que certidumbre en la implementación, la confianza, crear confianza en los sectores, en la vida práctica del teletrabajo y la concertación entre trabajadores y empresarios, más que la legislación unilateral por el gobierno, son los caminos que veo para la consolidación de esta nueva realidad laboral que forma parte del futuro hoy presente en el mundo del trabajo.
Muchísimas gracias, Daniel, por tus reflexiones, magníficas reflexiones. Quizá había algunas ocasiones que se iba un poco la voz por una señal débil, quizá para más adelante, si quieres dejar solo la voz y quitar el vídeo, porque se te escuchará mejor, porque había unas pequeñas interferencias, pero vamos, reflexiones muy acertadas sobre todo en el gran debate que luego podemos tratar entre todos de si es mejor regulación o negociación colectiva, o es mejor dejar algunos aspectos de las nuevas formas del trabajo, de teletrabajo, más efectivamente a la negociación colectiva y no tanto a la ley, ¿no? Por los límites que eso conlleva. Bueno, pues siguiente panelista que tenemos también la fortuna de contar con él es con Michael Burd, desde Inglaterra, que también todo el ámbito anglosajón y el derecho anglosajón siempre nos aporta una luz distinta, ¿no? Que quizá a la que tenemos en la referencia de Europa continental, y las prácticas de las empresas anglosajonas siempre también son realmente interesantes. Michael, cuando quieras aportarnos tus reflexiones.
Thank you, Íñigo. Like Christina and several others on the call, I am also a lawyer. Our firm is based in the City of London, and we have some 325 lawyers, of which unusually 160 or so are employment lawyers. So as you can imagine, we have been giving a lot of advice around remote working in 2020. And of course, we've also had to advise ourselves as we adjusted to these new circumstances. If you had asked me 1 year ago whether I envisaged being in a position of trying to manage some 300 people based in their bedrooms, living rooms, and kitchens, I probably would have laughed. But that's been the reality that so many of us have had to deal with over the course of this year. We've been hearing, really what we've been looking at here is the extent to which regulation in the workplace is appropriate in these new circumstances, and how it can adapt to facilitate new ways of working, encourage good practices, and discourage bad practices. And if you look really back at the entire history of regulation of the workplace, really over many hundreds of years, what you find is that generally speaking, the law and regulation lags behind the reality at work. And my sense is that has only increased with the advances in technology as they become quicker and quicker. And of course, it's been particularly acute in this year with the dramatic changes in working practices that were in effect forced on us all almost overnight. And for us, as we've grappled with this and seek to help our clients and their businesses through it, I think a few clear themes have emerged, which I would like to touch on today. The first one is a question of what is remote working. I mean, it can mean, as we've discovered, very many different things to different people. And indeed, it can actually mean very different things to the same person at different points of time. So just as one example, in the early stages of lockdowns, when schools were closed, many of us found that those of our colleagues who were struggling the most were ones where they had children at home who they were trying to homeschool, and juggling homeschooling and work was a huge challenge. In some cases, it was overwhelming. And many of those people during that period of time absolutely hated homeworking. But when the schools reopened and the kids went back to school, those very same people found that they had a very different attitude to homeworking. And many of them would tell you now that they find it very useful and helpful, and that they actually love it. But the one thing that has become clear, whether you love homeworking or hate homeworking, is that virtually everybody who you speak to, and we've heard this from some of our other speakers today, after many months of working at home in a rather isolated way, will tell you that they really miss the types of interaction that you get in the workplace, even if that is only going to be some of the time. They do miss it. And certainly, it has been my experience, and again, we've heard of this from other speakers such as Renate, that it is a huge challenge to mentor, to bring on, to train the more junior members of our workforce in circumstances where you cannot have that kind of growth which occurs when you're working together in close proximity, when people can overhear things, when they can attend meetings and observe things. Certainly we, and I think most businesses have a lot of work to do to work out how they overcome that challenge of bringing on junior talent in these new ways of working. There have also been, in our experience, a lot of issues around how remote is remote. And what I'm referring to there is many companies who phoned us up and they say, look, we have an employee who's gone home to be near his family in India or in China or in Italy, some other country. And is it okay? Can we continue to employ them? Are there issues and difficulties around that? And there are many. I mean, there's a question of which employment laws apply to the individual when they're based in the other country. To which country do they pay tax? Does the mere fact that you have somebody working in another country create a permanent establishment for the business that might mean the business has a tax presence in that country? And then there's a lot of issues around benefits. If you are an employer based in the UK and you have a private health cover that you provide to your employees, it's usually a UK only thing, and it's not going to provide them with health cover if they become sick, if they're based in India. But of course, they will have a contract that says you're entitled to private health cover. And there's all sorts of issues around pensions and other benefits as well. So, once again, the fact that employment law is local and employment regulation tends to be local makes it difficult sometimes for it to grapple with the globalized nature of work. Another issue that has been a very much a recurring theme around issues to do with health and safety at work. That was for many of us a rather fringe topic, and one that we didn't focus very much on, apart from a few specialists before COVID hit. But it's become really a major issue, and certainly in a couple of ways. First of all, there are issues which arise from the duty on every employer to provide a safe place of work for its employees. And that's impacted in two ways. What changes do you have to make to your office or your factory or your plant to ensure that it's safe when people attend? For example, can you control who comes in and who doesn't come in so that you don't have too many numbers, such as to prevent social distancing? And then on the flip side of that is how the obligation to provide a safe workplace impacts on people working remotely. What is the employer's obligation to ensure a safe place of work when somebody is working on their bed in their bedroom? And I've mentioned to my fellow speakers in the preparation a truly extreme and terrible example that I have been dealing with for a company who had a senior person working from home who was on a Teams call with a number of colleagues when it became apparent both to her and to all of her colleagues that her young child had drowned in a pool of water in the back garden of the house. And what is in those circumstances, what is the employer's responsibility? It's quite a difficult issue. Does the employer have to inspect the home workplace? What if the employer does inspect and concludes that the home workplace is not safe? Does the employer have to provide equipment, et cetera, et cetera? Many issues, and issues around working time. How do you police in those countries where there are working time regulations? How do you police rest breaks? How do you ensure that people take their holidays? And finally, on this health and safety topic, I think we are just about to come into some truly fascinating issues around taking the vaccine. Can you insist that your workers take a vaccine or not? If you have a worker who refuses to take the vaccine, can you say you are not allowed to come into work? Can you even go so far as to dismiss them? And historically, there's been a lot of protection for individuals and employees around medical data, which is considered to be very sensitive personal data. And I think before COVID, the sort of rights of the employee in relation to dealing with their own health would probably have outweighed the rights of the collective in relation to protecting group health. I think in the wake of this, that balance will tip. I think it will be possible for employer to impose consequences on employees who refuse to have the vaccine. So the balance between privacy laws and data laws and workplace regulation really intersect there and will throw up some major issues. And finally, if I may, and on a more positive note, because it's always good to have a positive note, I do think that the way in which we have all been thrust into the requirement to work remotely will have some benefits over time in relation to gender pay gap issues. The UK government, like many others, has a social policy unit called the Behavioural Insights Team. They seek to discover ways in which social policy tools can be used to influence public behaviour. And for the last couple of years, they have had a unit focusing on gender pay equality and how that can be fostered. And the studies they have done showed that one of the biggest obstacles to progression for women is the lack of workable, flexible working arrangements and the resistance that many employers historically have had to implementing them in a very full way. Obviously, COVID has hugely accelerated the prevalence of remote working, and it's also hugely accelerated the resources that employers are putting into making it work, and I think that's going to have a major impact. And certainly, if I look again at my own firm, the development which we brought about, which I am most pleased about, actually resulted from unusually having two problems and making them into a great thing. So the problems we had is that certain aspects of employment work for particular industries, particularly in retail and hospitality, where the margins are very, very slim, there was huge price pressure and certain work was becoming commoditized. And on the other side of the coin, we had junior female lawyers where there was a fairly recurring theme of them qualifying, becoming very skilled and talented lawyers, leaving to have a child, coming back perhaps part-time, having a second child and leaving for good, because for one reason or another, they couldn't make it work. And we brought those two problems together and we created a separate product specifically based at those industries. And we set up a number of our maternity leavers who did not feel they were able to return in their own homes. And the deal for them was that the clients could only call between 9 a.m. and 6 p.m. The clients pay a fixed fee for a monthly helpline, and they pay fixed low fees for certain low-level cases. And it's been a huge success. The clients are getting top quality advice and assistance from really great lawyers, and the lawyers love it. And these are women who certainly they would have left our firm, and almost certainly most of them would also have been felt forced to leave the profession. And we've managed to keep them in through that flexibility of working. And as I say, it's the innovation we've made, which I'm most proud of. And I do believe that these new ways of working will foster that kind of experience on a much wider basis. Thank you very much.
Thank you, Michael. Muchas gracias, Michael, por la exposición. Este ejemplo es un ejemplo de adaptación de una profesión como es una firma de abogados a una nueva realidad, y efectivamente es un buen ejemplo porque no es fácil. Y bueno, vamos a ver en otros sectores, ¿no? Quizá lo que también mencionabas de la flexibilidad, ¿no? La necesidad de las empresas en el mundo real a veces choca también con la realidad, valga la redundancia, de la ley, ¿no? Y a veces la ley, como bien mencionabas, en el caso del teletrabajo, por las obligaciones nuevas de los empresarios o por los derechos de los propios trabajadores también nuevos, pues a veces va por un camino paralelo a la flexibilidad que necesita la empresa en un momento determinado, ¿no? Y es importante saber y buscar el equilibrio, ¿no? entre los derechos de los trabajadores y también los derechos de los propios empresarios, ¿no? Bueno, continuamos ya el último panelista y luego ya haremos un pequeño debate con Hatsima Silova, que nos acompaña, como decía anteriormente, desde Sudáfrica. Y bueno, yo creo que nos va a dar una visión también bastante general y global de cómo ve este tema de las nuevas formas de trabajo y el teletrabajo en particular. Hatsima, cuando quieras. Muchas gracias.
Thank you very much. Thanks for the opportunity. I think, as others have said, that the coronavirus pandemic and the regulations necessary to balance keeping the economy going and people safe has no doubt brought in new challenges. I think, for us, you'll find that Zoom and other digital platforms were not the new in thing just before the virus, but now I think everybody is adapting to using most of these issues. Also, the issue of flexi times was always associated with the need for people to have multiple work, because you could not then hold a particular just one job. You needed to be able to have enough time to be able to do this one job and then the other at a different type. But now the new changes means that flexi is less about different working places, but more about being able to work at your own pace. And in many things, regulations tend to lag behind because we bump into new situations and then think, how can we regulate those particular areas? So I think, like it's happening in other countries, here, I don't think there's regulations as yet at looking at these issues, other than that government, labor, and business in a multi-sectoral forum would have asked that we focus on issues of how we can be able to encourage people to work from home, more to do with minimizing the infections and less to do with promoting new ways of working. But I think we'll have to find a way of challenging those issues. But also, if you some of you would be aware that initially at the International Labour Organization, the discussions about atypical work had to do more with people who were not doing work as in industries, factories, mines, shops. But now, atypical work will also have to include this new work situation that we're looking at. As has been said, how do you deal with issues of safety? How do you ensure social cohesion amongst the workers? Because I think working alone at home, while it gives you the flexible times, can also be very difficult because, as has been said, you don't have time to be able to ask a friend next to you, how do you deal with this one issue, and or learn from others as you sit from there. Now, if you look at Africa in general, and I'll speak about South Africa specifically, we have always had low internet penetration, yet the new situation demands that you need to have high internet penetration so that you are able to do that work. Of course, when you work from home, it is fine for people in senior positions, in middle management position, and or people who work in offices. What do you do with people who work in factories, who work in shops, you know, who are in the informal settlement? So those kind of people, I think, are left behind, and we therefore have to think through in this hybrid situation that we're talking about, or what people call the new normal. How are we going to accommodate those kind of people who may not be able to work from home because, I mean, assembly lines or mine work requires that everybody is there. Yet, you know, you're looking for new situations to deal with issues of, self-distancing. What do you do in the agricultural situation? Because most parts of Africa also rely in the main in terms of agriculture. It's easy to send home senior management, but it is very difficult. I mean, if you're going to pick up fruits, be it wines or vegetables, it is not something you can do online. It's not something you have to do it physically. So how do we find ways of also ensuring that we cater for this new situation? As has been said, while working from home is safe, it has its own challenges. Kids and family members tend to always come in because, you know, you can't say to a kid, look, mommy or daddy or uncle is busy. They see the parent being here at home and they think now it's time to be able to come. Sometimes people are not sure of Parliament, who even as they are making their own input, find that there are also other family members who are coming through. And I think we've got to come to terms with the fact that there will also be some interruptions to the work that we do from home. But how do we deal with these issues? Socialization, I've already spoken about. It is necessary. I mean, it's human nature to want to be with people. Yet you have to be able to isolate away from those people. How do we find a balance in terms of, you know, dealing with people in the fact that, as someone has said, you are not able to give people, if you have interns, it's fine to say, no, we'll be able to do it from home remotely. But sometimes you work by following what people are doing rather than just by someone telling you what is happening. So we need to find a way to deal with these issues. Supervision, I think, is a most difficult issue because, yes, you don't want to be supervising people on a day-to-day, hour-by-hour situation. But how do you deal with the fact that as human beings, we always play truant when the opportunity presents itself. And I think it's a challenge that all of us will have to work on too. And I foresee a situation where not only the discussions that we're having now, that the International Labour Organization and various multilateral organizations that includes workers, business, and the unions and government rather will have to say, how do we work on those issues? You know, the ILO is always looking at new conventions. I'm sure a new convention on this type of situation that we're talking about is going to emerge, which will help where, you know, in a number of countries, there are some countries that will be able to move forward easily, but others are going to lag behind. Others will need to be coerced in terms of that work. And to conclude, for me, is that, you know, where we are now is really just a start. But one we have to hope that we will, between now and next year, find better ways to combine, new ways to work with old ones that are safe. And I think for Africa, we will also have to improve internet penetration, because without that, all of these new ways of working from home, distance, is not going to become a reality. And therefore, you will find that you want people to work from home, you want self-distance, you want flexibility, but it may not be possible unless we're also able to bridge that digital divide more faster. Thank you.
Muchas gracias. Thank you, Hatsima. Muy interesante tus reflexiones, y quizá me da pie a una inquietud que también tengo y que quería ya compartir con todo el resto del panel, y que cada uno discuta o hable lo que considere, pero es relacionado con una cosa que estabas comentando de que, bueno, hay una cierta sensación por parte de los teletrabajadores de que el teletrabajo prolonga las jornadas laborales, las hace mucho más extensas. Es cierto que tiene otras ventajas que decía Michael, muy apreciadas por la forma de trabajar en casa y por la conciliación, pero también tiene un peligro de extensión de jornadas laborales. Aquí en España tenemos un derecho de los trabajadores a lo que se llama desconexión digital cuando llega a un determinado número de horas. Pero, bueno, es un derecho difícil de controlar y de reclamar por parte de los trabajadores, ¿no? Como quizás suceda con el tema de las horas extraordinarias, ¿no? Y yo quería conocer la opinión del resto de los panelistas, si realmente perciben que puede existir ese riesgo de jornadas continuas, y si realmente ese derecho a la desconexión digital, que por ejemplo está en Francia, no sé, Renate, si está en Alemania, bueno, puede ser una solución o es de difícil resolución, ¿no? Renate.
Thank you, Íñigo. Well, you see, this term right to disconnect is, of course, something which is a bit problematic from the employer's point of view, simply because it very much depends on what kind of activity you are doing. Obviously, you need to watch your working time. Everybody has the right to free time, obviously. But what exactly does it mean, right, to disconnect when you are a manager or an IT programmer or so? And here I think the legal framework shouldn't become too detailed. That's why also in our negotiations in the social dialogue at European level, we, as from the employer's point of view, we were of the opinion it is wrong for the European legal frameworks to establish at European level a right to disconnect. We believe that this has to be done at company level, where employers and employees or the works councils, they look at the different types of situations. I give you an example. When I'm a secretary, obviously nobody will be able or will be justified in requesting from me to check my emails or to look at an email after sort of office hours. But if I'm a managing director, and if I check my email at 8 o'clock in the evening, I think this shouldn't be prohibited. And that's why we say that this requires a more nuanced sort of regulation or nuanced framework, which shouldn't be strictly the legal framework, because in the legal framework we have, for instance, in Germany, but also at European level, we have the Working Time Directive with maximum working hours. And of course, this Working Time Directive with maximum working hours, which is a health and safety directive, obviously also applies to mobile work. But the way it is implemented shouldn't be done in a too rigid manner. Thank you, Íñigo.
Y como no tenemos mucho tiempo, yo quería hacer otra pregunta general, porque ya estamos acabando. Lo ha mencionado, no sé si lo mencionaba Daniel, poco referente a no solo en el aspecto del teletrabajo, sino también en general en las nuevas formas de trabajo, donde se va a requerir mucho trabajo freelance. Hay empresas que ya están contratando a un freelance Chief Officer en vez de un Human Resources Manager para manejar, controlar y organizar todo el trabajo de los freelance para las empresas, y luego todo el trabajo relacionado con la gig economy, con las nuevas regulaciones. Pero mi pregunta va un poco concreta: ¿cuál es el papel de los sindicatos en esta nueva realidad? Del teletrabajo, de los freelance, de la gig economy. ¿Cómo veis un poco ese papel de los sindicatos y qué retos tienen, ¿no?
Cómo no. En primer lugar, lo que debo decir es que creo que estas nuevas formas, y como Renate ha expresado muy bien, hay cuestiones que no pueden ser capturadas por la norma. Y como no pueden ser capturadas por la norma, y que además, a mi criterio, no es conveniente, porque la dinámica de las relaciones laborales va más allá, lo que tenemos es que preservar los ejes. En la ley general está el tema de jornada y obviamente si hay situaciones excepcionales, usos horarios, hay que ver el tipo, la naturaleza de las tareas a ese efecto. Y me parece que el campo de construcción de esas realidades es el acuerdo individual o el acuerdo colectivo. Es decir, cuando yo soy contratado para una tarea que exige tener en cuenta otros usos horarios, está claro que voy a tener que atenerme a esa construcción. Y probablemente, y no me cabe la menor duda que los sindicatos son capaces de hacerlo, se podrá tener el universo de ciertas actividades en los que aparecen problemáticas que, más allá de las cuestiones de health and safety, de seguridad y salud, que sí tienen normalmente un marco normativo de tipo general, incluso para este tipo de tareas, puedan entrar en cuestiones como el working time, la data protection, la reversibility, aquellas cuestiones que hacen a cada actividad. Y en ese sentido, el tema no es que los sindicatos se retraigan y desaparezcan, sino que casualmente se adapten a esas nuevas realidades. Porque lo que la tecnología está haciendo no es desplazar la función sindical, sino exigirle que mire con la mirada de la cuarta revolución industrial y no de la segunda o la tercera revolución industrial. Porque si los sindicatos siguen pensando en términos de segunda o tercera revolución industrial y la tecnología evoluciona como lo está haciendo en este momento, es evidente que va a haber un desfasaje. Y a esas realidades que tú aludes, Íñigo, y que probablemente se generalicen en fórmulas de trabajadores autónomos que necesitan algún tipo de protección social, pero que son fundamentalmente autónomos en algunos casos, o siendo dependientes, donde encontremos estas cuestiones. Me parece que es el camino del diálogo social y de la negociación colectiva, la vía, sin perjuicio de las normas marco que ya existen, o de la contratación individual, que también, sobre todo en los white collar y en determinados tipos de actividades de high-tech, prevalecen en los hechos.
Muchas gracias, Daniel. Totalmente de acuerdo, además, con tus palabras y tus reflexiones. Michael quería comentar algo respecto a mi primera pregunta de la desconexión y los nuevos derechos digitales. Michael.
Yes, and I might perhaps try to combine comments on the two questions. The problem that I see with the right to disconnection is that we live in an age of instant communication. And because we live in an age of instant communication, it has come to be expected. And with the expectation of instant communication, particularly if you are in a service industry, if you have customers and clients who expect you to respond and communicate instantly, then it becomes very, very difficult to reconcile that with disconnection. You have to be very innovative if you're able to manage that, and it's simply not always possible. So I'm not sure I agree 100% with Renate when she says that that's a decision that needs to be taken at a local, maybe an establishment level, because in many respects I see it as a society-wide issue. And unless and until the society adjusts its norms and expectations to allow disconnection, it will, for many people in many roles, be very hard to reconcile that with the demands for service that exist. Now, unions, I think, probably do have a role to play in that. As Daniel said, they need to, I think, join in that debate on that level. And they have, some role in helping perhaps to bring about some societal change, which will help that issue to be confronted head on. But I think until it happens on a very wide basis, we are going to struggle with that much in the way that the law struggled with looms and so on in the second industrial revolution.
Muchas gracias, Michael. Nos hemos pasado ya un poco de tiempo y ya tenemos que concluir. Simplemente yo quiero dar las gracias a todos los panelistas. Realmente ha sido muy interesante, una discusión muy fructífera. Probablemente el año que viene podríamos tener esta misma conversación, me imagino, no sé si online o offline, presencial o no presencial, pero coincido que las nuevas formas de trabajo están para quedarse. Hay un cambio estructural y muy probablemente tengamos esta conversación igualmente como las hemos tenido vía telemática. Pero la verdad es que estamos en un momento muy, muy interesante en todos los aspectos y en el ámbito laboral, pues yo creo que bueno, vamos a tener que ser innovadores, vamos a tener que ser creativos y bueno, adaptarnos a la nueva realidad, tanto las empresas como los trabajadores. Y creo que vamos a ver cambios regulatorios de calado en todos nuestros países. Y ya sin más, volver a agradecer a la asociación esta magnífica invitación y bueno, pues esperemos que en el congreso del año que viene en Colombia pues sigamos hablando de estos temas. Y nada, Diego, muchas gracias y te cedo la palabra para ya dar la despedida.
Thank you very much.
Muchas gracias. No sé si Diego quería dar unas palabras de despedida. Diego Solana.
Yes, sorry. I had some problems with the microphone. No, I want to thank you very much, Íñigo, for your extraordinary work gathering this extraordinary team and this great discussion. I also wanted to thank particularly Christina for hosting from London this opening session. I mean, this ongoing World Law Congress that we're arranging through this hybrid way, it was a proposal of Fernando Carrillo, former General Prosecutor of Colombia, and it was a challenge for the World Jurist Association. But with panels like this one, opening session like this one, I think we are fulfilling that expectation from Colombia and from all over the world, that people who are watching us. And it wouldn't be completed, this ongoing World Law Congress, without discussing the future of work. I mean, it would be incomplete. So thank you very much. I will see you all hopefully face to face in Colombia in November 2021. And if you are also interested in the next opening session, I will see you in January 19, next January 19, in an opening session focused on the future of higher education, led by the president of the Legislation and Jurisprudence Academia of Puerto Rico, Antonio García Paradilla. Thank you very much.